Welcome to the Probate Nation. My name is Richard Ruddy. As we have learned over the course of many shows, persons appointed as fiduciaries in an estate, testamentary trust, conservatorship, or for the property of a minor child all have to be bonded. In some appointments, the bond might be without surety, essentially a personal bond. In other appointments, however, the bond must have surety, and this means an insurance company must be involved. In Part 1 on enforcement of surety bonds, we learned that many of those fiduciaries must have a surety bond. And to get that surety bond, the fiduciary must agree to provide an indemnity agreement to the surety. We touched on a couple of the key provisions in the typical indemnity agreement in Part 1 as well. Tonight we will complete the discussion of enforcement of surety bonds. And during this program, we will look at other key indemnity agreement provisions, learn how and when the surety gets involved and undertakes to enforce the indemnity agreement against the fiduciary, the liability exposure of the fiduciary when there is a bond forfeiture judgment, and much more. We are pleased to have returning as our guests two attorneys who represent insurance companies that issue surety bonds. They will serve again as our guides as we conclude our discussion on the enforcement of surety bonds. Our first guest is a partner in the national law firm of Watt, Teeter, Hoffer, and Fitzgerald, located in its McLean, Virginia office. Her practice focuses on creditor rights and bankruptcy, including probate surety bonds such as administrator, executor, conservator, and guardian bonds. She is a board member of the Maryland Bankruptcy Bar Association and an active member of the American Bankruptcy Institute, the Northern Virginia Bankruptcy Bar Association, the Walter Chandler Inns of Court, and the International Women's Insolvency and Restructuring Confederation. She has written and presented on various creditor rights, bankruptcy, and surety issues. Our second guest is also a partner with Watt, Teeter, Hoffer, and Fitzgerald, and she is located in its Boston office. Her practice focuses on surety, construction, and insurance coverage. Her surety practice has a particular emphasis on commercial surety bonds, which includes all probate bonds. She is an active member in the American Bar Association's Tort Trial and Insurance Practice section and is a vice chair of its Fidelity and Surety Law Committee. She has written and presented extensively on various surety issues and is the author of a chapter in the ABA FSLC book entitled Probate Bonds. Please welcome attorneys Marguerite Duvall and Sharkrisha DiBartolo. Ladies, welcome. I'm telling you, every time I read that introduction, I think, my goodness gracious, I'm lucky to have you guys as my guests. All that brain power. So Sharkrisha, one of the things that we talked about in the first show, we really got into the application process to obtain a surety bond, and then we started to get into the indemnity agreement itself and talked a little bit about that. So let's go back again. Let's continue with the indemnity agreement. Let's talk about some of these key provisions that the surety can use to protect itself and recover its losses. So can you explain the importance and relevance of the provision of the indemnity agreement that allows the surety the right to settle or compromise any loss that occurs?
Certainly, Richard, and thank you again for having us back a second time.
Oh, of course.
So that provision essentially gives the surety broad authority to settle claims that are made against the bond. And it's there because sometimes things happen. The fiduciaries can disappear. They may die in the course of the administration of an estate, or they may stop cooperating with either the commissioner or with the surety. So there's a provision in the indemnity agreement that gives the surety the broad right to pay, adjust, settle, or compromise claims. There is, while the surety and the fiduciary have a similar interest, no one wants to see the bond called or money paid out under the bond. Sometimes positions are taken by a fiduciary that are either not justified under the law, or that sometimes fiduciaries may even just give up and stop participating in the process. And so the surety needs to have a way to be able to resolve claims, and this provision allows them to do it. There's also a second part to the provision that's also very important, and that provides that evidence of payments by the surety is prima facie evidence of the fact and extent of the indemnitor's liability to the surety. And that means that if the surety were to bring a claim against the indemnitor and present to the court the evidence that it's paid the claims, then it satisfies its burden of proof with respect to the extent of the indemnitor's liability to it and the fact that the indemnitor is liable to it. So it's a very important provision in the agreement from the surety's perspective.
Okay. Now, let's continue on. Marguerite, I'm going to ask you, can you explain the importance of the provision that gives the surety the right to require the fiduciary to place funds, basically to pay over funds to the surety even before there's any loss?
Yes. So quite simply, once the claim is made on the bond, and that is basically when sort of the Commissioner of Accounts of the court issues a show cause order to pull in the fiduciary or the surety, or sometimes it could be a simple notice of a hearing. Once a claim is made, depending on what is really at issue in that claim, the surety has the right to then turn to its principal, it's the fiduciary of the estate, and say, a claim is made for $10,000. Looks like that's gone missing, or you haven't accounted for that property. There might be a loss on the bond, and so that the surety doesn't have to afterwards chase down the fiduciary, the principal, for those funds. If there is a loss, it's sometimes easier to ask for things up front before people spend their money. The surety might send out a letter or a demand, should I say, and say, there looks to be a loss of $10,000. We are demanding that you post with us cash of $10,000. If the claim is only $5,000, then the surety, and I say if the loss under the indemnity agreement is only $5,000, then whatever's left over will be returned to the fiduciary. If, however, it exceeds the $10,000 demand, the surety can still try to get recoupment reimbursement or be paid back from the principal for anything over that. But the idea is that the surety doesn't want to have to be out of pocket if there looks to be a loss. And the best person to make sure that doesn't happen is the person who is primarily responsible for all of this, and that is our fiduciary.
So yeah, so if you get a letter like that from a surety company asking you to put up some money all of a sudden, I would think that would get their attention, that maybe they ought to get on the stick and fix whatever the problem is. So let's, Shakrisha, can you explain the next provision I want to focus on is this provision that authorizes the surety to investigate statements, obtain credit reports, and so on. Tell me about this provision and how that relates to the indemnity agreement.
Sure. Well, I think one of the parts that's probably most important for your viewers in this section is the fact that the indemnity agreement gives the surety the right to obtain credit report information. And it does that for a couple of reasons. One is it's, and the surety can do that really at any point in the process, during the application process, during enforcement of the indemnity agreement. And it gives the surety both information. It's like when you apply for a loan for a car, for a credit card. It allows the surety to see what your financial stability is, and it needs to know that both when it's issuing the bond. It also would want to see that information if it needed to proceed under the indemnity agreement, and the indemnity agreement gives it the power to be able to do that. Okay.
Now, is there a provision in the indemnity agreement that somehow where the fiduciary can acquire, where the fiduciary has to give the surety some sort of security interest or lien? And what does that, how does that work? Or
well, that's a provision that's also in the indemnity agreement, and it's automatic from the standpoint of when the application and the indemnity agreement is signed. It gives the surety a security interest in the fiduciary's title or right and proceeds to any insurance policy. That can come into play, for example, if one of the fiduciaries is an attorney and there's a claim of negligence against the attorney that could trigger a malpractice policy, for example, the surety has a security interest from the outset in any proceeds of that policy, for example.
Now, I'm just curious though, do the bonding companies normally file UCC-1s to actually record that security interest?
They can. I have to be honest, I haven't seen one in the probate context. I've certainly seen it in contract surety. Marguerite, I think, may have some experience with that in this context, but it's definitely something that can happen, especially if you have an estate with considerable value. So the surety would want to have that interest recorded early on, so it's not something that comes up later where they haven't perfected that interest.
Of course, of course. Marguerite, I'm going to turn to you as we go to the next topic, which is where the surety gets involved. So when exactly does surety get involved in an estate or a conservatorship?
So we're going to go with when we typically get involved. I mean, things change from case to case, and so it just depends. But oftentimes what happens is we will receive a show cause order for why the fiduciary shouldn't be removed as a fiduciary and why the bond shouldn't be forfeited. Sometimes we get notice earlier on where, particularly, let's say in Fairfax, the commissioner of accounts will hold more informal hearings, well, not informal, but will hold formal hearings, not at the court level, but the commissioner level, and we'll notice the surety. And depending on what's going on, the surety might send an internal claims representative to that, or they might hire outside counsel, just again, depending on the reason for why the commissioner is holding the hearing but once it goes to a show cause order, then the attorneys will get involved because we have to represent the surety in court. The surety can't just send, someone from their claims office down. They have to be represented by counsel in court. And that generally means that the principal or fiduciary hasn't been doing what they're supposed to be doing, or there's funds missing, and there's a legitimate concern that something is awry.
Sure. Now, I will say that certainly many of the commissioner's office, and certainly in Fairfax, the commissioner's office is very proactive in the sense that they will write letters and they will listen to what you have to say. If you got a good reason why you haven't done something, they'll certainly give you time to get stuff fixed. But at some point they reach the limit of what they can do and they have to move the ball. And that's where you then get those show cause notices, which is not a good thing. And now the court's involved. So please be responsive to those. Carisha, let's take a look now. Is there a progression of involvement by the surety? I mean, I know Marguerite kind of talked a little bit about that, but maybe you could fill that out a little bit more.
Sure, Richard. Well, typically, it kind of depends on what's happening with the estate. If it's something like an inventory hasn't been filed and the surety gets notice of that, and there's no need for the surety to actually appear in court, you may just get someone from their claims department writing to the principal to say, hey, we've got this notice, your inventory is late, or your yearly accounting hasn't been filed, what's going on? And so you might just have that kind of involvement from the surety at the claims level and not with an attorney right away. And of course, if you got correspondence like that from the surety saying, hey, what's going on? Why haven't you filed these things? You should respond to that right away and see if you can get it fixed, and let the surety know that you're on top of it and that you're taking care of it. Because if you don't, and then you get something like a show cause hearing, that's when the surety's involvement will get more significant. They might have to go and hire an attorney. And that's when the costs start to add up that the surety is going to start looking to the fiduciary to compensate it for. So it can vary. I think it starts at the claim level, and then depending on the severity of what's happening and whether or not you need to be, the surety needs to be represented in court, then it might actually go out and hire counsel. Okay.
Well, let's turn now to the surety's rights and remedies and this is really important. So, Carisha, let me start with you again. Review for us the key rights the surety has against the fiduciary, if you would, please.
Sure. I mean, the primary and key right is that the surety has the right and the discretion to act, including settling claims and investigating claims. And once it does that, it has the right to indemnity from its principal for the costs of anything that it incurs. And one of the important things about that discretion is that in almost all jurisdictions, as long as the surety acts in good faith in responding both to the claim from the standpoint of the costs it incurs, as well as what it pays, if it pays anything to resolve a claim, most jurisdictions will say as long as the surety acted in good faith, it has the right to recover what it paid, its costs, its attorney's fees, everything from the indemnitor. So that's a very important right, and it's upheld in almost all jurisdictions.
Now, is the standard of good faith hard to meet for a surety?
No, it's not. And actually, it's really it's almost the other way around. An indemnitor really has to show that the surety has acted in bad faith or somehow in collusion with the parties that they've paid in order to get out of paying the surety back under one of these indemnity agreements.
Okay. Now, Marguerite, what are the consequences of a judgment for forfeiture of the surety bond?
Well, in Virginia, Richard, when the bond is forfeited, the judgment is entered jointly and severally against the bond principal or fiduciary and the surety. And ideally, the surety would love it if our bond principal paid that judgment, but more often than not, the courts in the states or the conservatorships look to the surety to make that payment. And when the judgment is entered jointly and severally, there's actually a Virginia Code statute, Virginia Code section 49-27, that grants the surety very simply a judgment then against the bond principal for the amount that is paid, plus a 5% statutory penalty. So once the surety pays, we get, let's say, for example, bond forfeiture is $100,000. If the surety pays that, then there's, by statute, the surety can move by motion. It's often all done in one order, though. By statute, we get the $100,000 judgment against the bond principal plus a 5% penalty. That's $105,000. And then we get post-judgment interest. And that's important for people to know that that's 6% per annum by statute. So that those numbers can add up very quickly if you're not careful. In addition, this by statute, it provides for an assignment of the original judgment to the surety. So the estate has a separate, or the conservatorship has a separate judgment against the bond principal. And once the surety pays, that by statute gets assigned to the surety. Again, all this is generally taken care of in one order for bond forfeiture versus going through the steps, which is better for everyone because it just means less fees and court involvement. It takes care of it at the same time, but sometimes they do have to come, the surety will have to expend additional resources once they've paid to come in. So I know you haven't asked me yet, but I would say at this point, my comment is if you know that you're going to be facing bond forfeiture and you can't pay, my recommendation is to avoid continuing accrued attorney's fees by the surety is just to make sure that everyone gets taken care of in one big order, because these are rights that are there. So whether we get it on Monday or we get it on Friday, it's going to happen. And so sometimes it's worth just being cognizant that, again, the loss includes our attorney's fees, and you don't want to have to pay attorney's fees you don't have to pay.
Sure. I mean, certainly I advocate that being forthright, whether with the Commissioner of Accounts Office or with Surety Bond Counsel, is to make things go as smoothly as we can, recognizing we have a problem, and let's see how we can fix the problem. Along the way, recognizing as well that we have to protect the rights of somebody who has incurred a loss, which is the surety company. Now, Marguerite, there's this concept called equitable subrogation. Can you explain what that means?
In simplest terms, it means that once the surety pays any portion of its claim, it steps into the shoes of the other party. So, for example, I would say in the context of the estate, if the estate gets a judgment against the bond principal and the surety pays, the surety now steps into the shoes of the estate, whereas it's estate cap is the best way. Like it basically dress up, you're now the estate. And if the estate has certain rights, because of that debt that has now been paid, the surety can, acting essentially as the estate, can then enforce those rights, whether it's against the bond principal or some third party in the sense of recoupment or repayment of that. I think most recently, the way I've seen it play out is we had money transfer for one estate that was bonded to another estate, and that estate had funds, still had those funds there. And so the surety paid out on the bond and was able to step into the shoes of the estate that it paid the bond for and make a claim to have the return of the funds back, because that return of funds was part of why the bond got forfeited. And so the surety was able to essentially net out a zero loss for a portion of the bond forfeiture of that, acting sort of with the state hat on.
Okay, well, Margaret, I'm going to continue with you though, because I think, you know, I think if people are listening to this show, they might, if they're not, if they're trying to beat the bond company, so to speak, you know, can a fiduciary who's been bonded with surety, who now has had a bond forfeiture, can they walk away from their obligation by filing bankruptcy?
No. This is, I'm sure anyone heard the beginning introduction. This is actually one area where I get a little excited about, because it's where I primarily practice. We keep talking about our bond principals as fiduciaries. They are fiduciaries. They're entrusted with assets and funds of another party. And under the Bankruptcy Code, and it's called Section 523A4, there are grounds to deem the debt due to the surety non-dischargeable. That means if you file for a Chapter 7 or a Chapter 13 or a Chapter 11, the surety could say they embezzled funds, they breached their duties as a fiduciary, and that's why this debt arose. So as a result, it should be deemed non-dischargeable, which means it'll stick with you. There are also other provisions. 523A6 involves intentional injury to property of another. So if for some reason the fiduciary here purposefully did something that caused damage to property, and again, we talked about equitable subrogation, if we stepped into the shoes of the estate and the estate's property has been damaged, we could seek to find the debt deemed non-dischargeable forever in existence as a result. And then there's a provision under 523A2 that talks about the statements that you made to the surety in order to get the bond issued in the first place. And I know we touched briefly on some sort of questions that are asked when you fill out that bond application. Mm-hmm. And it's important that you are asking, it's akin to asking for credit. And so if you lie in obtaining credit and you lie in your bond application, another aspect, even if the debt itself may not have been, let's say, the loss incurred by the estate, but the attorney's fees portion or something like that, all that is caused by your lie to the surety company. The surety company could also come after you that way. So there's a couple different avenues under Section 523 of the Bankruptcy Code to deem the debt owed to the surety or the surety acting as the estate non-dischargeable, which I think most people think of student loans as being non-dischargeable, and I would say there's a few things certain in life: death, taxes, and debt, and or student loans. And in this instance, the 523 Acts kind of make the surety debt a lot like student loans. You're stuck with them.
Well, that's very interesting, Marguerite. Now I want to go ahead and turn. We got just a little bit of time left. I want to get your closing comments from each of you. This advice, practical suggestions, and so on that you might want to share as we've now finished the second show in this process. So, Sharkrisha, I'm going to go to you first.
Okay, thank you, Richard.
You're welcome.
I would just say, don't ignore the surety. The surety is not your enemy, but it has significant power under the indemnity agreement, both to resolve issues and to come after you if it has to pay for something. So stay up to date with what you need to provide to the court. Don't ignore the surety. Provide it the information that it's asking for, and hopefully you can work through the issues both to your benefit and the surety's.
Marguerite, how about yourself? What would you like to share?
Well, I think Sharkrisha stole my thoughts out of my head. I was going to say the exact same thing. Yeah, I mean, if you get a notice from the commissioner, or you get a notice from the court, or you get a notice from the surety, or you get a notice from an attorney representing the surety, get back to us, get back to them, because it has a snowballing effect. And if you need help, hire an attorney, hire an accountant. A lot of the issues we see can be avoided from the beginning. Again, we see some very simple forfeitures that should never happen. For example, people just don't keep documentation of an expense that they made, and those numbers add up. Or they fail to file an accounting and don't do that. And we didn't get into it, but there are additional costs that happen when you, let's say, get replaced. So it quickly adds up if you do not respond to people.
Ladies, I want to thank you both again, Marguerite DeVol and Shakrisha DiBartolo from the law firm of Watt, Teeter, Hoffer, and Fitzgerald for, again, taking the time to come back and visit with us on the Probate Nation to share with our viewers your extensive knowledge, advice, and experiences on the enforcement of surety bonds. You know, really, again, valuable information for executors and conservators, and really a great public service to the Northern Virginia community. So thank you again for taking the time. Over the course of 2 shows, we have learned a great deal about the surety bond, from how it is obtained, the indemnity agreement that a fiduciary must give, and the liability a fiduciary may be subject to if he fails to perform key tasks as a court-appointed fiduciary. None of this comes into play if you simply do the job that you assumed when you were appointed and bonded with surety. We encourage fiduciaries, whether bonded with surety or not, to get advice early from a qualified attorney with experience in fiduciary matters. And please do not ignore a notice from the Commissioner of Accounts that you have not done some task. Legal advice and timely responses to notices will serve you well and keep you out of trouble. This brings us to the conclusion of our 2 shows on enforcement of surety bonds. Hope the shows were informative, and remember that replays of both of these shows and all shows today can be viewed on the Probate Nation website. On behalf of myself and the Probate Nation, thank you for visiting with us.